All right, I think I am live. That's my guess. Hopefully, I'm right. So, welcome everyone. Thank you for joining me. My name is Lior Samfiru. Hopefully, you know that. I am the employment lawyer, and I'm one of the founding partners of Samfiru Tumarkin LLP. You may have seen me on TV or heard me on radio. What I do anytime you see me is I talk about employment law. And that's exactly what I'm about to do right here. I talk about employment law. I answer questions. This is a live session dedicated for you, made for you, so that you have an opportunity to ask questions, to make sure you get your questions answered and you can leave with the information you need to have. My firm, Samfiru Tumarkin, we operate across Canada, well, specifically in Ontario, BC, and Alberta. And if you're in one of those provinces, I can help you. I can answer your questions. I can tell you what you need to know about your workplace rights. Thing is about employment laws, people across Canada don't understand and appreciate just how good laws we have in this country. Some of the best employment laws in the world. Many people don't know what those laws are. So how can the law help you if you don't know what the law is? Well, that's exactly why I'm here and why you're watching me right now, so that I can help you understand what your rights are and answer your questions. So if you're facing a difficult situation in the workplace, maybe your boss is mistreating you, maybe someone else is mistreating and your boss is not doing something about it. Maybe you think they're trying to convince you to leave or they're pushing you out. Maybe they're treating you unfairly. Or maybe you were let go, you lost your job, what to do about it. Whatever the issue, whatever the problem, ask the question. It starts right now by asking the question, giving me the opportunity to help you and answer those questions so you can be armed and feel powerful because you have the knowledge. Now, let me give you some other information before we get started answering questions. If you want to connect with me and my team, we have a large team across Canada. If you want to connect with us privately, by phone, by email, here's how you do that. All you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address below me. And that's our website that has, number one, a lot of information about employment law that you can read and understand, but it also has all our contact information, my phone number, my email address, the contact information for each and every one of our team members. Everything is right there at employmentlawyer.ca. So if you want me to roll up my sleeves and get to work to actually help you, it starts with employmentlawyer.ca. So take advantage of that and go there. For those joining me, hey, welcome. My name is Lior Samfiru, the employment lawyer. This is the employment law session that I do to answer your questions, to help you understand what your legal rights are in the workplace. There is no bad questions. There's only answers and solutions. So let's start answering questions right now. Ask your question. You have time. Don't wait till the last minute. Oftentimes people do, and I don't get to answer the questions because they come in at the last minute. So ask your question right now. Let's start with that. First question of the day, and welcome to William on YouTube, who says, why do companies hold on to your profile and don't give it to your lawyer? I don't know what you mean. Why do companies hold on to your profile and don't give it to your lawyer? I don't know whose profile and why would they give it to your lawyer and why would you have a lawyer? I'm sorry, I don't know what you mean there, William. You're going to need to elaborate for me to be able to answer that. Okay, next question from Lauren. Can your boss decide to extend your probationary period? Well, the short answer to that is no, your boss can't do that. And the reason for that is a probationary period, for it to have any meaning, can only be 3 months. And remember, you're only on probation if you signed an employment agreement that says specifically that you're on probation for 3 months. It's not automatic. So if you never signed an employment agreement that says you're on probation, you're not on probation. So because you can only be let go without compensation in the first 3 months, and only if you sign an employment agreement that says that, your probation can't really be extended, because if you're let go after 3 months, you're going to be owed compensation. You're going to be owed severance. So no, as a practical thing, your employer may say that, yeah, we've extended it, but it doesn't have any legal meaning or legal effect. So for all intents and purposes, a probationary period can only last for 3 months. But remember, it's not automatic. A lot of people assume I started a new job, obviously I'm on probation. No, you're not on probation unless you sign an employment agreement or job offer letter that specifically says you are on probation when you start the job. Okay, so thank you for that question, Lauren. I'll continue answering questions right now. See how easy it is? Hey, I'm Lior Samfiru, the employment lawyer. Ask your question, take advantage, type it in, press enter. I'll see it, read it, answer it. Next question from Alitha on YouTube. Okay, yes, you emailed me, Alitha. Thank you. Don't know if you have any questions. So if you have any questions right now, this is the time to answer. This is the time to get those answers and hopefully understand what you're dealing with if you have a workplace problem. All right, now, with that said, as between your questions, as we're waiting for more questions, what I wanted to talk about is some of the biggest employment law violations that even large employers are guilty of. So some people think that, well, it's only small companies that don't know what to do and the small companies that do things wrong. No, big companies, large companies see this all the time, every day, all day, do things wrong and illegally. So I want to, in between your questions, talk about some of those situations. But your questions are always a priority. A question just came in. I'm going to answer that right now. Again, ask your question as well. From J. Marie on YouTube. Is there such a thing called a voluntary layoff in Canada when experiencing employment hardships such as change in the company and harassment to meet standards when it's difficult to do so? So no, there's no voluntary layoff. What there is, if your job is changing or if you're facing harassment, that may cause what we call a constructive dismissal. What that means is that if your job is changed or something happened that makes it difficult to continue working, you may be able to leave, resign, but you can treat that resignation as a termination of your employment. The law looks at it, it's as if your company let you go, and then they have to pay you severance. So a constructive dismissal happens when your employer does something, changes your job, your compensation, your hours, or maybe bullies you, harasses you. As a result of that, you leave. In the eyes of the law, that's a termination, and your company has to pay you your full severance as if they had let you go. And remember, that severance is as much as 24 months pay. So, J. Marie, if you think you've been constructively dismissed, before you do anything, before you quit, before you do anything like that, you call me, okay? You reach out to me, let's have a chat, and let's make sure we do that properly. And J. Marie, to connect with me, as I said before, or my team, to have that private chat, easy. Just go to employmentlawyer.ca. You see that address below, employmentlawyer.ca. Write that down, check it out, phone number, email address, it's all there, okay? employmentlawyer.ca. Thanks for that question. Continuing to answer questions from Diane. Diane's up next. If your company is sold to another company, are you automatically terminated? Well, you're automatically terminated if you don't continue working with the buyer. So if you don't have an offer from the buyer and you lose your job because the buyer's not taking you on, then you're terminated and you're owed severance. If you choose not to accept an offer with the buyer, then you are terminated and you're still owed severance. Now, if you have an offer from the buyer, but you decide not to accept it, depending on the reason you didn't accept it, you may get your full severance or you may not get your full severance. If you had a good reason as to why you didn't accept the offer, maybe because they were hiring you under different terms or different pay or different role, you have a good reason. In that situation, you're owed your full severance, even though you chose not to accept the offer. If you don't have a good reason, you just say, you know what, I don't want to work for that company, I'm going to go somewhere else, because you don't have a good reason, you're not going to get your full severance, but you're still going to get your minimum entitlements. But it's not automatic. It's only if you don't continue working, whether because you don't have an offer or you choose not to work, then it's a termination, then you're owed severance, okay? And by the way, if you're presented with a job offer letter by a buyer, your business is sold, that the buyer is offering you an offer, be very careful what you sign, because you don't want to give up your past service. If you don't give up your past service, they inherit it. So the new company, the buyer, inherits your past service unless you sign an employment agreement that gives that up. So don't do that. If you're presented with an agreement like that, let me see it. Let's talk about it. Let's discuss how to deal with it. Don't just sign, because that could cost you tens of thousands of dollars, maybe even hundreds of thousands at some point. So thank you for that question. Alitha has a question on YouTube. Is it legal for an employer to change work policy contracts without notice to its employees? Well, it depends on what you sign. If you sign an agreement that gives them the power to make those changes, then they may be able to do it. But it really does depend on what you sign, how it's drafted. Is it clear? Is it not? Is it enforced? So the question becomes that. If you sign specifically a document, put it differently. A company has the right to do the things that you give them the right to do. So if you give them a right to do something, they can do it. If you didn't give them the right to do it, then they may not be able to do it. That's the best way to look at it. Good questions coming in today. You see how easy it is, everyone. So ask your questions. For those that are just joining us, welcome. My name is Lior Samfiru. I'm one of the founding partners of Samfiru, Tumarkin LLP. We're the largest employee-side law firm in the country. And I'm here live right now answering your questions. That's what I'm here doing, answering your questions about employment law, workplace rights. If you have an issue, a question, a problem, ask your question live right now. I'll answer it. Next question from Eve M on YouTube. If a demand letter is sent and the employer does not respond, are you then forced to file a claim? If so, you submit a claim for the same amount or a larger amount. Well, okay, if you send a demand letter to your former employer and they don't respond, you have two options. You give up and you walk away, or you have to start a claim. It's up to the individual. You don't have to. There's no law says you have to start a claim. But if you're hoping to get compensation from your employer and they're not responding to a demand letter, then you have no choice but to start a claim. Now, in terms of the same amount or larger or smaller, you have to decide that with your lawyer, depending on the situation. Maybe it's exactly the same, maybe it's less, maybe it's more, depending on the case and what you're owed and the value of your case. So there's no rules in terms of it has to be the same amount or not. It has to be the amount that the lawyer feels is the appropriate amount that the individual is owed. So that's the answer to that. But really, that's a question you should have your lawyer answered. If you're not working with a lawyer, you got to contact us right away so that we can understand your situation. And by the way, if the company doesn't respond to a demand letter, I have ways to make them respond. Okay, so that shouldn't be an issue. Good question there. Continuing to ask questions, you can ask yours, take advantage. You still have plenty of time. Next question comes from Francis. Does your workplace have to have COVID policies for health and safety going forward as we head into fall and winter? Yes, they do need to have policies as to how they deal with the spread in the workplace, how they deal with people with symptoms, how they deal in situations where someone tests positive. Yes, they need to have policies and procedures with that. It's obviously a serious matter, COVID. Now, they don't have to have policies that say you have to be masked. They don't have to have policies that say you have to have a vaccine. But certain things to protect employees in the event that there's exposure in the workplace, they absolutely have to have these policies. They can't just let employees do whatever they want and hope that no one gets sick. And if your employer doesn't have proper policies and doesn't take COVID-19 seriously, that could be a breach of the Occupational Health and Safety Act or legislation. That could also result in a constructive dismissal. Certainly something that the employer has to take seriously. Okay, if your employer doesn't take it seriously, that's a problem. You have to reach out to me, and I'll be more than happy to talk to you and help you if needed. I think I'm caught up here on question, but you should ask your question as well. Take advantage. Make sure that when this session ends and you turn off your computer, you don't have any more questions left in your mind. You've had those questions answered. Maybe it's one question, maybe it's 5 questions. Whatever it is, ask your question so that you know what you need to know. Now, I said that in between your questions, I'll talk about things that even large employers do wrong. Large companies that breach employment law rules and regulations. And one such breach that I see, again, even large companies do, is not properly deal with workplace harassment complaints. So let's be very clear about this. If an employee complains to their employer that they're being harassed or bullied, the company must take it seriously. They can't ignore it. They can't put it on the back burner. They can't say, well, it's your problem, you resolve it. The employer by law has to take it seriously, has to get involved and investigate, make sure that they understand exactly what happened, conduct a proper, unbiased investigation. And then, of course, once the investigation is done, take whatever actions are necessary to rectify the harassment so it doesn't happen again, because every employee has the right to work in a harassment-free work environment. Okay, so very important that an employer does that. I have seen situations where they don't do that. They don't take it seriously. They don't try. They don't want to investigate, or they don't know how to deal with that. That's wrong. That's illegal. And I've seen many large companies do that. Banks and large organizations. So if you're dealing with a company, you've complained about harassment or bullying or a poisoned work environment, and nothing happens, well, if you try to deal with the company, let me talk to them. Usually once they hear from me, they become good boys and girls. They do what they're supposed to do. I give them the kick in the pants. And ultimately, if they're still dropping the ball, we can get you out of there with compensation. So don't assume just because you're working for a large company, they're doing it right. Too many times, unfortunately, I've seen large companies, small companies not deal with harassment properly. If your employer doesn't deal with it properly, let me know. You can connect with me. And to do that, of course, you know the address, employmentlawyer.ca, to connect with my team and I. Very easy to do. Again, employmentlawyer.ca. All right. Continue to answer questions. Guys, more questions. I want those questions. I need those questions. So ask them right now. Make sure that you have answers before the session is done. But next question is from Farah. I was hired on a verbal agreement, not a formal contract. After a family emergency, I couldn't work a shift and was told if I didn't come in, I would be fired. Can they do this? Well, no, they can't. Even if you miss a shift, that's not cause for dismissal. And depending on the situation, depending on the family emergency, they may have the obligation to accommodate you under human rights laws. So bottom line is, even if you don't have a good excuse and you miss a shift, listen, let's be very clear. You shouldn't miss a shift if there's no excuse. I get that. But the fact that you did, and maybe you did something wrong, does not mean that the company can just fire you for cause. They would have to pay severance, and they would have to pay full severance. That could be as much as 2 years' pay. How many times a company says, well, you did something wrong, we can fire you for cause? No. The only time a company can fire an employee for cause if an employee is guilty of some very significant misconduct and where it's so bad that it's just not possible to employ the individual. Too many times companies pull the trigger before they should, and that's a wrongful dismissal. Okay, so Farah, hopefully that answers your question. If it doesn't, ask a follow-up question, or easy, connect with me off air, off social media through employmentlawyer.ca. All right, but right now, more questions. Let's continue. Next question, follow-up from J. Marie. I could possibly face termination as I'm on a performance improvement plan. They threaten I will get terminated with cause if I don't meet it. Can they do that if I can't meet performance at no fault of my own? No. They can terminate, but not for cause. The only time they can terminate for cause is if you're almost deliberately doing a bad job. You're almost trying to sabotage the company. But if you're doing what you can and you still can't meet those performance milestones that they've set, the only way they can terminate you is without cause, which means they have to pay you severance. Okay? So don't worry about it. Do your best. Do your job to the best of your ability. Make sure that they know that you're doing your best. If they let you go, you contact me. I'll make sure you get the severance that you're owed. Now, for J. Marie and for everyone else, if you want to know, well, how much severance am I owed? How much would they actually have to pay me? Here's how you do, or what you do to find out right now. We have our severance calculator. Easy to find. All you do is you go to pocketemploymentlawyer.ca. You see that right there, pocketemploymentlawyer.ca. When you go there, you'll see our severance calculator. You can click on it. And then you can find out in seconds how much severance you're owed, whether you're owed 2 months pay, 6 months pay, 24 months pay, or anything else. It's easy to use. It's completely free. It's completely anonymous. You don't have to put in your name or the company's name. You don't have to put in your phone number or anything like that. It's free and it's easy, and it's going to tell you how much you're owed. And by the way, you may think, well, I've only worked for a company for a few months. I'm probably not owed much. Nonsense. Even if you work for a company for a short period of time, you are probably owed months of severance. Months, not days, not weeks, months. Short service employees are treated disproportionately better than longer service employees. So I don't care if you work for 30 years or 30 days. If you lost your job, go to pocketemploymentlawyer.ca, use their calculator, know how much you're owed. Maybe you're worried about losing your job. Maybe you've actually lost your job and you're staring at that severance offer and you want to know if it's legitimate, if it's good, or if it's bad. Pocketemploymentlawyer.ca. Use our severance calculator. By the way, across Canada, it's been used over 2 million times. That tells you something, okay? So check it out. J. Marie, hopefully that answers your question. You know what to do if there's a follow-up, or connect with me easy through employmentlawyer.ca. Now, before this last run of questions, I was talking about violations, employment law violations that even large employers are guilty of, not just small employers. And another one, a big one, a common one, is putting employees on a temporary layoff, okay? On a temporary layoff. So an employer does not have the right to just put someone on a temporary layoff. In most situations, that results in a constructive dismissal. In other words, your company, if they put you on a temporary layoff, you can choose to accept it and wait at home and hope for the best. That's option number one. Or option number two is you can choose to treat that as a termination of employment and get your full severance. Employer, by putting me on a temporary layoff, I am making the decision, me, to treat that as a termination. Now, employer, too bad, you have to pay me my severance. That is something you can do in most situations. And I've seen countless large employers either don't get that or hope that the employee doesn't know that. Putting an employee on a temporary layoff, no automatic right to do that. Of course, we're only talking about non-union employees. Non-union, very, very different for union employees. But non-union employees, your employer does not have a right to put you on a temporary layoff. If they do, you can treat that as a termination. Now, by the way, the same was true even during COVID-19. Thousands and thousands and thousands of people across Canada were put at some point on a temporary layoff because of COVID-19, right, over the past couple of years. Even in those situations, not legal, okay? Even if it's because of COVID-19, even if your employer is not a bad employer, and maybe they are dealing with financial issues because of COVID-19, even in those situations, your employer does not have a right to put you on a temporary layoff. You can choose to treat that as a termination of employment. If that's what you want to do, you know what to do. You contact me, easy to do, employmentlawyer.ca. We still have 10 minutes or so. You have still some time to ask questions about your workplace rights, about employment law. You see how easy it is. We had a bunch of questions. You type it in, you press enter, I read it, I answer it, you're done. Very easy to do, so take advantage of that. Now, in between your questions, again, I'm listing a few violations that even employment or large employers are guilty of. Another one, again, tied to severance, is employers offer crappy, inadequate severance. Large employers do this all the time, every day. In fact, most of the time, over 90% of the time, when someone loses their job, whether it's a big company or a small company, the severance that they're offered is a lot less than what they are owed, a lot less. So chances are, if you lost your job, regardless of the reason, maybe it's a good employer, not a good employer, maybe it's a good reason or a bad reason, but whatever the reason is, if you lost your job, you're looking at that paper, there's an offer there, chances are, over 90% of the time, you are owed much, much more than what you've been offered. I'm not talking about, well, I'm owed an extra week's pay or 2 weeks' pay. Now, that would be bad enough, right? I'm talking you're owed an extra 6 months' pay or 12 months' pay. Happens all the time. Very, very common. That's why I'm here, right? And that's why I keep stressing the issue of severance, because you are owed and you have significant severance rights and severance entitlements. And chances are your company's not going to give those to you until you tell them, hey, I know that offer is not good enough. I know that I'm owed more. Then they'll say, oh, crap, you called us on it. Okay, fine. How did you know? Well, you know because you listened to me, you watched me, and now you know. But large companies do that. So what I don't want you to do is I don't want you to assume that just because you're working for a large, sophisticated company, they must know how much severance they owe. So if they've offered me 3 months, that must be all I'm owed. Nonsense. Either the company itself may not know what they owe, or they hope that you don't know. You're owed 8 months, they've offered you 3, and they hope you'll accept it because you don't know any better. Well, if you're watching me right now, if you see me on TV, if you heard me on radio, you know better. Okay, so don't let that happen to you. You can go to pocketemploymentlawyer.ca to calculate your severance. You can call me and my team. We can help you ensure you get your severance. Once you sign off on that offer, even if you realize the next day it was a huge mistake, but once you sign off, there's no going back. Every single week, I speak with individuals that signed off on that offer and they want my help. And I have to tell them, I can't help you. Once you sign, once you accept, and even though you realize you're owed another year's pay, I can't help. Don't let that happen to you, please. You're watching now, you know better. You lose your job. I don't care who you are, what company you work for, what kind of a job, or how long you've worked. You call me, you email me, employmentlawyer.ca. But that's for after. Right now, you still have the last few minutes to ask your questions, get answers. So let's continue. Next question comes from Sharon. Sharon asks, if you feel you are being pushed to quit by your employer, what are your options? I don't want to lose this job, but I feel I'm being forced out. Well, first of all, you should not. You don't have to quit just because your employer wants to. So you can say, "Thank you, employer. I'm not quitting. I'm staying here. And if you want me gone, employer, you can't let me go. You're gonna have to pay me my severance." Remember, if your employer is trying to force you out, what they're hoping will happen is that you will just quit, and then they save a bunch of money. They don't have to pay severance. So they probably decided that you're not going to work there anymore, but they're hoping you're going to do them a favor by leaving, because otherwise they'd have to pay you 10-month severance or whatever it is. But if you leave, they'll say, hey, I don't have to pay you anything because you quit. That's on you. Too bad. I just saved a bunch of money. So be very smart about that. Now, if you can show that your employer is forcing you to quit or threatening you or making your life uncomfortable, if you can prove that, you have emails, you have recordings, you have a way to prove that, then that's a constructive dismissal. If you quit in that situation, the law still looks at it as a termination and you're owed your severance, okay? Because no one should have to work in a situation where they're being forced to leave. But the best advice I can give you is you do your job. If your employer wants you gone, let them make the move. Don't give them a gift. Don't make it easier for them to try to avoid paying you the severance that you are legally owed. All right? So do it that way. But again, if you want to talk about how they're making your life miserable and what we can do about that, then no problem. Just reach out to me off air. I'll be happy to have a chat with you, and I'll be happy to help you and deal with it. All you do is employmentlawyer.ca. You see that address below me, and I'll get that. We'll connect by phone, by email. Easy to do. So let me continue with at least one more legal violation that even large employers are guilty of, not just small employers, and that is they don't properly accommodate a person's medical condition. So if you have a medical issue, a disability, a physical limitation, your employer has a very strict duty to provide accommodation. It's not optional. It's not a nice to have. It's a legal requirement, which means if your doctor says you need modified duties, they have to provide modified duties. If your doctor says modified hours, again, they have to do it. Maybe your doctor says for medical reasons you have to work from home. Well, your employer has to accommodate that. Your employer has the requirement to accommodate whatever your doctor says. Your doctor is judge and jury. If your doctor says you need that accommodation, your employer has to give it to you. Too many times employers say, oh, we don't want to, that's too hard, we don't really believe your doctor. I've seen a huge amount of large employers do that. So you understand that by doing that, if your employer won't accommodate, won't try hard enough, ignores your doctor, it's illegal. That's a human rights violation. Okay, they can't do that. So if that happens to you, give me a call. I'll deal with it. All right, employmentlawyer.ca. I'll take one last question here before we wrap up for the day on YouTube from Rody. Can I record a conversation between my employer and myself while I'm on the employer's property? Yes, you can. Yeah, as long as you are part of the conversation, you're legally allowed to record. What you can't do is record conversations that other people are having when you're not part of that conversation. So you can't leave the recorder in the boardroom and record the people talking there. But if you're talking to your boss and you have a recorder in your side pocket there, you can record. There's no law that says you can't do that. In fact, in many cases, that could be very, very helpful. That could be a way to prove what's been said, or that if you've been mistreated, it's a very good tool to have. So it's not a problem. You can use that, and the law does not impose any penalties or in that situation. Hopefully that helps, Rody. And that's the time we have for today. Again, for those that joined me today, thank you. My name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. And even though I'm going to turn off this computer in just a moment, I'm not going anywhere. I'm getting back to work on a different computer. So you can email me. You can call me. You can call my team. Just go to employmentlawyer.ca. Again, employmentlawyer.ca to connect and have all that contact information. I'll be back next week, but don't wait until then. Ask your question today or connect today to discuss your legal matter. Thank you very much, guys. Always appreciate being here. Always great questions. Thank you for joining me. My name is Lior Samfiru. I'll see you soon. Thank you.